Few people want to go to jail, and a few may attempt to assert some level of control over a situation they are not in control of by exposing first responders or others to their bodily fluids and then claiming to be carrying a disease. In this event, the Texas Code of Criminal Procedure outlines procedures for having a defendant tested for a disease. According to the CCP, a defendant arrested who, during the offense or arrest or during a judicial proceeding, causes a peace officer, magistrate, employee of a correctional facility, emergency response employee, or volunteer to come into contact with the defendant's bodily fluids shall, at the direction of the court, undergo a medical procedure or test to show whether the defendant has a communicable disease. The court may direct the defendant to undergo the procedure or test on its own motion or on the request of the peace officer, magistrate, correctional employee, emergency response employee, or volunteer. If the defendant refuses to submit voluntarily to the procedure or test, the court shall require the defendant to submit to the procedure or test. In other words, the defendant is not going to have a choice. Notwithstanding any other law, the person performing the test shall make the results available to the local health authority, and the local health authority shall notify the peace officer, magistrate, correctional employee, emergency response employee, or volunteer of the result. The state may not use the fact that a medical test was performed on a defendant or use the results of the test in any criminal proceeding arising out of the alleged offense. The test will be conducted in accordance with standards provided by the Department of State Health Services. Finally, nothing in this section of the CCP authorizes a court to release the test results to anyone other than the person specified.